So what is a venue clause? My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. And today we're going to look at a pretty common contract clause that you may not have really paid attention to before. So when you're working with contracts, they can be long, they can be short, they can have a lot of really intense provisions that are really long and detailed. They can have really short ones that are maybe just a few sentences long. But whatever the nature of your contract, there's usually a set of clauses near the end of the contract that we see in most contracts. There's things like jurisdiction and venue clauses that we're going to talk about today. There can be severability clauses, notices, other provisions, definitions. There can be all kinds of what we call boilerplate language at the end of your contract. And for many of my clients, their eyes roll back in the head by the time they get to that part of the contract. They're 25 pages in, they understand kind of what's in the beginning, then there's an indemnification clause, and then we have an issue with taxes, and then there's notices, and it just seems like there's too many clauses. And by the time they get to the end and they see something called a venue or jurisdiction clause, chances are their eyes are rolled back in their head already and they're not even paying attention. Most people don't look at a venue clause that carefully, but it's important to do so because it can really affect the future of your contract if there becomes a problem. So what a venue clause is it says that if there's a dispute under the contract, it tells you where that dispute can be heard. So for example, if you're here in Minnesota and you're contracting with someone from Alabama, the venue clause will likely say if there's any dispute, the dispute should be handled in either Minnesota or Alabama, because normally one or the other party will want that clause to say that the disputes are in their home courts. So you'd want the Alabama company coming up to Minnesota if you're located here in Minnesota, so that you don't have to travel all the way to Alabama and find a new attorney down there. You've probably been working with an attorney for years. They're located here in Minnesota. Maybe you have a yearly lunch with them to kind of go over the state of your business and what some next year's ideas are on the legal front. So you don't want to have to travel to Alabama and find somebody new. It's also important to understand what the venue says when it says to what kind of contract or what kind of court you're going to end up in. So sometimes it'll be a state court, sometimes it'll be a federal court. So depending upon the nature of your contract, the amount at issue, and where everyone's located, you need to understand whether the venue is going to be in your state court or in your federal court. But the venue is a really important provision that a lot of people never really pay attention to. And those who do pay attention to it are often people who've already been in lawsuits. So again, if you've been sued by somebody, and let's say you're here in Minnesota and you're dealing with someone in Ohio, and they've sued you in the local Ohio court, you're now stuck trying to find an attorney in Ohio to represent your business because you can't represent your business. It has to be represented by an attorney. And now you're essentially playing ball in somebody else's ballpark. It's not a home game for you. You're in Ohio as an out-of-state company trying to deal with an Ohio lawsuit. As opposed to, you can be here in Minnesota where you locally know everybody, you know your attorney, you know the parties, and your attorney knows your local state courts. So when given the option and when you're looking at a venue clause, you want to make sure you understand where venue is being laid for any contractual disputes. Now, sometimes we'll have kind of a dual clause that'll say if the breach is by one party, it goes to this court. If the breach is by the other party, it goes to that court. Once again, I don't recommend that because then you're trying to figure out who's doing what. And then also, if you have a counterclaim, now how do we figure out which court you should be in? So the reality is focus on your venue clause and understand where any dispute should be heard. You want to make sure you know what state you have to be in. And so then people often ask me, all right, fine, I understand. I've got to read through my contract, but what should I do when it comes to the venue clause? And the answer is just read it, understand it. And if you don't understand it, talk to your attorney, talk to the other party, whoever drafted it, and make sure you understand what that venue clause means and where any disputes would have to be heard. You don't want to find this out down the road that, again, you're a New York-based company and now you're litigating a case out in Arizona because that's what the contract says and you never knew that was coming. That's a lot of travel and finding a new attorney for a jurisdiction that's far away from where you're based. If you're not sure about your venue clause or you want to talk about updating the venue clause in your contracts, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page. If you click that, you'll be taken to my personal calendar where we can set up a 15 or 20-minute phone call. We call them legal strategy sessions, and we can discuss the venue clauses or whatever other legal issues you're facing and give you some ideas for some next steps and some options for moving forward. If you found this video to be insightful, I'd love it if you hit that like button, and if you want to see more videos like this, feel free to subscribe to the channel. We're always adding new videos in the business and the estate planning world. Look forward to seeing you in our next video.